दोस्तों नमस्कार। तो आज वो दिन आ ही गया जिसका हमें 16 मार्च 2013 से इंतजार था। महाराष्ट्र का जो केस था जिसमें एकनाथ शिंदे की सरकार बनाई गई, उद्धव ठाकरे ने जो इस्तीफा दिया और 16 विधायक जिनको डिस्क्वालीफाई करने का मामला था, उसे आज सुप्रीम कोर्ट ने उस पर फैसला सुना दिया है। सुप्रीम कोर्ट ने बोला है कि राज्यपाल का फ्लोर टेस्ट करवाने वाला जो फैसला था वो गलत था। सुप्रीम कोर्ट ने यह भी बोला कि स्पीकर को, जो पार्टी का व्हिप है, उसके खिलाफ दूसरा जो विरोधी ग्रुप है उनका व्हिप अपॉइंट करना और उसको मान्यता देना भी गलत था। लेकिन सुप्रीम कोर्ट ने बोला कि हम उद्धव ठाकरे की सरकार को दोबारा बनने का आदेश नहीं पार कर सकते, क्योंकि उद्धव ठाकरे साहब ने खुद अपने आप इस्तीफा दे दिया है। ये फैसला सुप्रीम कोर्ट के कॉन्स्टिट्यूशनल बेंच, जिसमें 5 जज थे, उन्होंने सुनाया है। इसकी सुनवाई 16 फरवरी 2023 को शुरू हुई थी। 8 हियरिंग चली थी और 8 हियरिंग के बाद यह फैसला आया है। इस फैसले का जो ऑपरेटिव पार्ट है वो चीफ जस्टिस ऑफ इंडिया डॉक्टर धनंजय चंद्रचूड़ साहब ने सुनाया है। मैं आपके सामने उसको सुप्रीम कोर्ट की वेबसाइट से ही लेकर के उसको सुनाता हूं। सुनिए।
Immensely grateful to your Lordship.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions. in view of the principles of natural justice. Based on the submissions which have been in canvas before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam. Arabia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. One, whether the temporary disablement of the functions of the speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And two, whether a constitutional hiatus believes that the motion is well founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And three, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Kyoto Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. Members of neither faction may validly raise the defense that they are the political party in the event that each faction of the state government is a constitutional functionary who derives his authority from the Constitution. This being the case, the governor must be cognizant of the constitutional bounds of the power vested in him. He cannot exercise a power otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented them from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request. Defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating communicated by the Deputy Secretary to the Maharashtra Legislative Assembly dated 3 July 2022 is contrary to law. The Speaker shall recognize the whip and the leader who are duly authorized by the Shiv Sena political party with reference to the provisions of the party constitution after conducting an inquiry in this regard and in keeping with the principles discussed in this judgment. E. The Speaker and the Election Commission of India are empowered to concurrently adjudicate on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. F. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of the case before it. G. The effect of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where 2 or more factions claim to be that political party. H. The governor was not justified in calling upon Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach the conclusion that Mr. Thackeray had lost the confidence of the House. However, the status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. And I, the governor, was therefore justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. This batch of writ petitions is disposed of in terms of the conclusions and directions recorded above.
तो ये जजमेंट है दोस्तों, सुन लिया आप लोगों ने। अब मामला वहीं का वहीं रह गया है। स्पीकर के पास में गया है, स्पीकर व्हिप के हिसाब से फैसला लेंगे, लेकिन उद्धव ठाकरे मुख्यमंत्री नहीं बनेंगे। ये वीडियो आपको बना करके शेयर करना जरूरी था, क्योंकि सुप्रीम कोर्ट का फैसला आया था। आशा है आपको ये वीडियो अच्छा लगा होगा। अगर ये वीडियो अच्छा लगा तो इसको लाइक करें, मेरे चैनल को सब्सक्राइब करें, कमेंट करें और दोस्तों यारों के साथ में शेयर करें। धन्यवाद। जय हिंद, भारत माता की जय, वंदे मातरम।